Chair Flores Fang, we are ready to begin.
Welcome to the March 14th, 2025 regular meeting of the San Francisco Ethics Commission. Today's meeting is live cablecast on SF.gov TV and live streamed online at sfgovtv.org/ethicslive. For public comment, members of the public may attend in person or may participate by phone or the WebEx platform as explained in our agenda document. Clerk, can you please explain how remote public comment will be handled?
Public comment will be available on each item on this agenda. Each member of the public will be allowed 3 minutes to speak. For those attending in person, opportunities to speak during the public comment period will be available here in room 400, City Hall. For those attending remotely, the public comment period can also be provided via phone call by calling 1-415-655-0001. Access code is 2661-052-0560, followed by the pound sign, and then press the pound sign again to join as an attendee. When your item of interest comes up, press *3 to raise your hand to be added to the public comment line. Public comment is also available via the WebEx client application. Use the WebEx link on the agenda to connect and press the raise hand button to be added to the public comment line. For detailed instructions on how to interact with the telephone system or WebEx client, please refer to the public comment section of the agenda document for this meeting. Public comment may also be submitted in writing and will be shared with the Commission after this meeting has concluded and will be included as part of the official meeting file. Written comments should be sent to ethics.commission@sfgov.org. Members of the public who attend Commission meetings, including remote attendance, are expected to behave responsibly and respectfully. During public comment, please address your comments to the Commission as a whole and not to individual members. People who engage in name-calling, shouting, interruptions, foul language, or other distracting behavior may be excluded from participation.
Thank you, Clerk. I now call the meeting to order. Clerk, will you please call the roll under item 1?
Commissioners, please verbally indicate your presence by saying aye after your name is called. Chair Flores Fang?
Aye.
Commissioner Salahi?
Aye.
Commissioner Francois? Aye. Commissioner Ye?
Aye.
Chair Flores Fang, with 4 members present and accounted for, you have a quorum.
With that, I call agenda item 2, general public comment. Are there any speakers in the room here for public comment? Hearing no request for public comment in the room, I'd actually just like to make a comment myself. I'd like to welcome our newest commissioner, Commissioner Ye. We're excited to have you here and look forward to working with you. Hearing no other public comment in the room, can you please proceed with any remote public comment?
Chair Flores Fang, it looks like we have callers in the queue. Welcome, caller. You have your 3 minutes begins now.
Can you hear me now?
Yes.
Great. It's David Pilpel. Good morning. Member of the Sunshine Ordinance Task Force. The task force referred an item to the Commission last year regarding an alleged willful violation of the Sunshine Ordinance. The Commission staff responded last month, essentially dismissing the matter with little information to explain. Efforts by the task force chair did not yield new information. I understand that a communication from the task force chair to this Commission in the last few days has now resulted in a meeting scheduled next week to discuss the matter further. Depending on how that meeting goes, the matter might need to be escalated further to the Commission Executive Director and or the Commission Chair for further discussion, both on the substance and the handling of the particular matter and the regulations and the manner in which the Commission and the staff handles referrals from the task force. The task force does not refer many matters to the Commission, usually no more than once or twice a year, and I believe those matters should be taken seriously and perhaps should be heard by the full commission regardless. So I encourage you to consider the matter, and I can answer or try to answer any questions you might have at this time. Thanks very much.
Thank you. It looks like we have another caller in the queue. Welcome, caller. Your 3 minutes begins now.
All right. Well, 3 minutes. Anybody know how to read? Like read the U.S. Constitution? So the First Amendment of the Constitution, and I'm not to be interrupted at all. My name is San Francisco. Seventh generation San Franciscan. This ethics committee was established about 30 years ago. Don't know what the hell anybody's doing down there, but they're all fucked up, and I can use profanity if I choose to do so. I don't know where Finlove is, or Finelove, or Finger Sniffing, whatever the hell his name is, but thank God he's gone. And look.
Chair Flores Fang, there are no callers in the queue.
Thank you. Hearing no further members of the public wishing to speak, general public comment under item 2 is now closed. I now call the consent calendar. Colleagues, as noted on the agenda, there will be no separate discussion on a consent calendar item unless a request is made by a commissioner or a member of the public in attendance. In that event, the matter will be removed from the consent calendar and considered as a separate item. Does any commissioner wish to discuss any item on the consent calendar? My only comment is to acknowledge Deputy Director Gayathri's last day. We thank her for her service. Does any member of the public wish to discuss any item on the consent calendar? Anyone in the queue?
Chair Flores Fang, there are no callers in the queue.
Thank you, Clerk. Public comment on the consent calendar is now closed. Commissioners, hearing no further discussion, do I hear a motion to adopt the consent calendar? So moved.
Second.
Clerk, will you please call the roll?
On the motion to adopt the consent calendar, Chair Flores Fang,
Aye.
Commissioner Salahi,
Aye.
Commissioner Francois, Commissioner Ye,
I'll abstain.
Chair Flores Fang, with 3 votes in the affirmative, the motion is approved.
I now call agenda item number 6, staff presentation on public financing program post-election report. Our audit manager, Eamon Wilson, can you please introduce the item?
Yes, thank you. Good morning, commissioners. Welcome, Commissioner Ye. Again, for the record, I'm Eamon Wilson. I'm the commission's audit manager. And if you could give me just a sec to bring up a presentation. So some quick background. This is the post-election report for the public financing program regarding the November 5th, 2024 election. City law requires the commission to prepare this report after each election in which members of the Board of Supervisors and the mayor are elected. And this is part of the code that established the city's public financing program. So this program was created by proposition back in 2000. And basically what it does is it allows mayoral candidates and supervisorial candidates who can demonstrate that they have a certain level of community support, and that is that they have received contributions from San Francisco residents that reach a certain threshold. They can have those funds matched with public funds to help offset the cost of running a campaign. So all these, the rules, deadlines, thresholds, filing obligations, these are all codified in the city's Campaign and Governmental Conduct Code, and the Ethics Commission administers this program. So in this presentation, I'm going to avoid rehashing what's in the report and going through the full program background. I want to focus on sharing some of the key stats data that made this really a record year for both the public financing program and for campaign spending in general, again, on mayoral and supervisorial campaigns specifically. And I also want to highlight what goes into administering this program on the staff side, and also to tee up a particular aspect of the public financing program that is demonstrably ineffective, and staff would like to explore potentially a legislative revision to roll back this particular aspect. So with that, I'll start with the public financing and election spending trends. I want to start by noting that all the data in the report and in this presentation was pulled from the data dashboards that the Commission makes available on its website, thanks to our EDA team. And all that data, in turn, was pulled from the multitude of campaign filings of disclosure statements that are filed with the Commission. So this first chart shows the number of publicly financed candidates by election year. So you can see that 2024 saw a record number of candidates who received public financing. That dark blue represents the supervisorial candidates, the lighter blue is the mayoral candidates. So you can see that 2010, for example, had about as many supervisorial candidates as received public financing in this year. 2011, there were actually more than double the number of mayoral candidates. One of the trends that we'll be seeing moving forward is that in 2022, in that election, voters approved Proposition H, which moved mayoral elections from odd years to even years. So somewhat ironically, the last time there were publicly financed mayoral candidates, this was a special election in June 2018. So in 2018, we saw public financing for both supervisorial and mayoral candidates. That was a special situation. But moving forward, every 2 years, we'll see both mayoral candidates and supervisorial candidates. Sorry, every 2 elections, we'll see both mayoral candidates and supervisorial candidates. So it's possible that we'll see this record number of publicly financed candidates on an ongoing basis. And from an audit's perspective, these are the candidates that represent our mandatory audits. So the code requires the Commission to audit all publicly financed candidates. So this is our pool of audits that we're currently working on. Okay, and in line with a record number of candidates, we also saw a record amount of public funds dispersed. So you can see that the total was more than $8 million in 2024, split about evenly between supervisorial candidates and mayoral candidates, because as citywide candidates, the code allows mayoral candidates to receive more public funds. There's a higher cap there. And a key point here that likely resulted in this larger amount of public funds dispersed was that in November 2019, there were a number of amendments passed for the public financing program. And this included increasing the maximum amount that candidates could receive. And it also increased the matching ratio from 2-to-1 to 6-to-1. And what this means is that for every dollar in contributions that a candidate gets approved, public funds will match it at a rate of 6-to-1. So this was before my time with the Commission, but going back through the meeting minutes and whatnot, this seems to be in line with other jurisdictions that also have a public financing program. And at any rate, we do see that this resulted in a greater percentage of total candidate spending coming from public funds after this change than before this change. This chart shows public financing as a portion of total candidate spending. Unlike the prior 2 charts, this combines mayoral and supervisorial candidates. So again, record year in 2024, total candidate spending was almost $27 million. Of that, $8.8 million came from public financing. So I don't have the percentages here, but you can see that a chunk of each year comes from public financing. And I have some numbers here. So for supervisorial races, public funds averaged in the past 10 elections 49%, so basically half of total candidate spending. It was 62% in 2020, so higher, and in 2024 it was as high as 68%. So in the supervisorial races, we are seeing that public funds are making up a significant portion of total candidate spending. For the mayoral race, it was about 40% in both 2011 and 2018, only 22% in 2024, and you can just eyeballing the chart see that it's less. And that leads in, it has to be said that one of the major stories in this election was that a significant amount of the spending came from a single mayoral candidate, namely Mayor Leary, of course. And of that spending, the majority of that was the candidate's personal funds. So the city has a $500 contribution limit. That limit does not apply to a candidate's own funds. So this $9.5 million, these are the personal candidate funds that Mayor Leary invested in his campaign. So again, eyeballing it, it's about a third. I think it's about 26% of total candidate spending this year came from that alone. So if we discount that outlier, we're still looking at about 44% of total mayoral spending coming from public funds. So the trend is holding minus this kind of anomalous year. Okay, yes. All right, so now this is total spending. The last piece of the puzzle is third-party spending. These are independent expenditure committees not coming from candidates. So this $26.8 million in 2024, we saw that in the prior slide. That's total candidate spending for this year. Then there was an additional $19 million in third-party spending for a record total of $45 million. That has massively higher than all previous elections. And this has been the largest amount of third-party spending in both mayoral races and supervisorial races that we've ever seen. The percentage of total spending is actually in line with the 10-year trend for supervisor races. But in the mayoral race, even with the anomalous amount of candidate spending, third-party spending was still the highest percentage it's ever been, at 45% compared to an average of 23% in the two prior elections. So all this to show that we saw record supervisorial spending, record mayoral spending, record public financing, and record third-party spending in 2024. And I can move on to talking about how the public financing program was administered. If you have any questions about stats, I'm happy to take those now. Okay, great. So this is a timeline showing what the public financing cycle looked like in 2024. So the bolded and italicized dates, these are baked into the code. The unformatted dates are just when filings happen to begin. So qualifying requests, this is what candidates submit. It's an initial package of contributions they submit to the commission that in order to receive initial matching for those contributions. So here there's a minimum number of contributions they have to provide and a minimum dollar amount they have to provide. So they get between, in this case, it was February 5th and August 27th to be initially qualified for public funds. And then overlapping that and extending to 1 month after the election, they will then submit matching requests. And here there isn't a limit on the number and amount of contributions. And essentially whenever a candidate has contributions that they'd like matched, they can send these over to us. Commission staff will review, determine if they meet all the requirements, and then they will match those funds. These two other timelines on the bottom are reviewing threshold statements. So in the proposition that created the public financing program, it also created this requirement that candidates prepare and submit threshold statements. So there's an initial threshold, anytime a supervisorial candidate reaches $100,000 in expenditures or in contributions, they reach that initial threshold, and within 24 hours, they have to file a report with the commission. And then after that, every time they reach $10,000 additional dollars in contributions or expenditures, they have to file a report with the commission within 24 hours. For mayoral candidates, that initial threshold is $1 million in contributions or expenditures, and then after that, it's every $50,000. So as you can imagine, that's a lot of filing, a lot of tracking that the committees have to do real time in addition to their more regularly filed Form 460 campaign disclosure statements. So in 2024, mayoral and supervisorial candidates filed 263 threshold statements. And I'll also note that this isn't just our publicly financed candidates. All candidates in a race in which there is at least one publicly financed candidate, they then have to file threshold statements as well. And then finally, also during this period, staff are calculating individual expenditure ceiling adjustments, and I'll go into that deeper in a little bit. So as you can see, it's administering the public financing program it's essentially lasts the entire election year. The audits division is responsible for administering this program, which it makes sense from an operational point of view to do that because we're reviewing the same types of records that will ultimately audit, and all these candidates are the candidates that will ultimately audit. So it makes sense operationally, but this in past years has really occupied essentially 100% of the division's time. So we really need to focus. That's one of our priorities this upcoming year before we reach the next election year, to streamline this where possible. Like I mentioned at the beginning, if we can see some legislative amendments to roll back the threshold statement requirements and the IEC requirements, individual expenditure ceiling requirements, we can move away from being an audits program that can really only have the capacity to do audits every other year. So that's a preview of what the timeline looks like. This chart kind of puts into perspective what reviewing qualifying requests and matching requests look like. So you can see under qualifying requests, the total that were submitted to the commission and the total that commission staff reviewed, and then the total that were approved. So those 27 that were approved are our 27 publicly financed candidates, and you'll see that that's about half of the total submitted. And this is because there are those the minimums on number of contributions and minimum amount. So candidates won't always reach that. They'll submit a bundle of contributions. If they don't reach that threshold, it'll be withdrawn or rejected. So it might take a couple tries for candidates to become approved. Once they are, then they'll continue submitting those matching requests. And these are approved at a much higher rate. Individual contributions might be rejected, but generally whatever's submitted and approved in a submission, they will get those funds matched. So in total, we saw 27 qualifying requests and 96 matching requests. As I mentioned, those requests are bundles of contributions. So the actual number of contributions was 13,000. And so staff need to go through, and it's still quite a manual process at this point, to ensure that each of those 13,000 contributions came from a San Francisco resident, didn't exceed a limit, that there's some reasonable evidence to show that this payment was actually received by the committee and that it was actually tied to that contributor. So this really demonstrates why we need to streamline this program, and we're going to make better use of technology, do automation wherever we can. But it's a bit inescapable. Ultimately, the commission needs to put the stamp that, yes, these 13,000 contributions are qualified. Okay, so the individual expenditure ceiling, this is that program that appears to be ineffective, especially in this past election cycle. So some quick terms. The individual expenditure ceiling, as the name implies, this is a cap. Publicly financed candidates cannot spend beyond that cap. So the initial IAC is $350,000 for supervisorial candidates, $1.7 million for mayoral candidates, but this can be adjusted or increased. And in order to do that, there's a formula in the code. Staff have to add the total opposition spending for a candidate to the highest total supportive funds of their opponents. And I'm going to illustrate what this looks like in the next slide. And so these IECs have to be increased in increments of $50,000 for supervisorial candidates and $250,000 for mayoral candidates. So I wanted to give a quick overview of what this looks like, because in the next commission meeting, or maybe one after that, our policy team will come forward with some recommendations on how to address this program. So I wanted to do a quick run through of what this analysis actually looks like. So this example is taken from an actual supervisorial race. This is from mid-October. And so what we have here is for our 4 candidates, each of them has total supportive funds and total opposition spending. So the green bar is the funds that the candidate themselves have actually raised. The yellow bar is third-party supportive spending. So these are third parties who are making advertisements, whatever, supporting that candidate. So adding those together gives the candidate's total supportive funds. And the total opposition spending is any spending by rival candidates or third parties opposing that candidate. So these are the 2 pieces of the equation. And these blue bars are the candidate's IEC. So you can see that here, this is mid-October, half a month before the race. The IECs for each candidate is above the funds they have actually collected. So these are purely hypothetical at this point. The candidate has this IEC, but they don't have enough funds to actually reach it. And you can see there are 2 less well-funded candidates, A and B. They're not going to get close to that IEC, even candidate D. These are all academic. So candidate C is getting close to it, but again, they don't have the funds to actually reach it. So what the analysis looks like is on a Wednesday, staff, they review the threshold statements that have come in, they review independent expenditure reports, they see that there's been some new activity in this race. And so in this chart, there was about $100,000 in new contributions that candidate D received, about $50,000 in new spending targeting candidate C. So as this new financial information comes in, staff will calculate how this impacts each candidate. So for this, we're just going to be looking at the analysis for candidate C. So the total opposition spending against candidate C is $95,000. Their best funded opponent, the highest total supportive funds for their opponent, is candidate D at $580,000. So we add those 2 together, and their IEC needs to be above $675,000. And their current IEC is $550,000, so it needs to be raised. And again, in the code, it has to be raised in increments. So it'll be pushed up to $700,000. Ultimately, those are 3 incremental jumps it makes, and they have a new IEC. So great, their IEC has been adjusted. It still doesn't actually impact their ability to spend. They didn't have those funds in the first place. So this shows the total adjustments that commission staff had to calculate in the 2024 election. And that second column, third column, are the instances in which the funds that a candidate had actually exceeded their IEC. In other words, they had funds that were locked. They were not allowed to spend. So in this campaign, only 12 of 295 actually had a real impact on a candidate's ability to spend. Beyond that, though, staff are having to calculate 295 adjustments. And what this last column shows are the rounds of analysis. These are really days in which new information is available for a given race that staff will then go through this process of calculating for each candidate. So the total number of days is 65. And you can see, given the total for each of the individual races, it was on 65 distinct days that that commission staff had to perform this analysis for 1 or more races, and typically it's multiple races. So in that period between April and election day, on average, every 2 days, staff are performing this analysis, only 4% of which actually made a difference to candidate spending. Okay, and then this last chart shows on election day the total amount of funds that candidates had raised and what their IEC was, really the difference between their funds and their IEC. So starting on the supervisorial side, by election day, every supervisorial candidate but one had an IEC that was tens of thousands of dollars greater than the funds they had raised by election day. So this seems to indicate that removing the IEC.
And we look forward to the revisions. I don't think there's an exact date.
Right. I think the policy team at this point, I don't know if it'll take research, it'll take some studying again to see what the impact is. I think their next proposal will be more an introduction of all the various campaign finance potential amendments they'll be looking at.
Great. That's very helpful. Okay, let's take public comment on the matter.
Chair Flores-Fang, it looks like there are 2 callers in the queue. Welcome, caller. Your 3 minutes begins now.
Can you hear me now?
Yes.
Great. David Pilpel, again, still listening to the meeting. Very helpful report on the public financing that's required after each cycle. I also wanted to comment on the last item. I believe after you took public comment, there was a vote on the consent calendar, and I believe the newest commissioner abstained from the vote on the consent calendar. Charter section 4.104 sub B, last sentence, requires any member present to vote yes or no on a matter unless recused. In accordance with law, does not allow for abstentions. Also covered in the City Attorney's Good Government Guide, page 24 to 25 and page 152 to 153. I would encourage you to go back to the consent calendar and secure a vote one way or the other from the newest commissioner on that matter. But again, thank you to the staff for the report on public financing. Thanks.
Welcome, caller. Your 3 minutes begins now.
Well, all right. Contribution thresholds. Wow, what a topic. Let's see. So last election, we contributed our threshold too. We really don't have a threshold. Our threshold being number of votes. We contributed to Daniel Lurie over 25,000 votes through our vast networks. So really appreciate the funds and everything else, but community doesn't have a ceiling for contribution. What they do is they just go out and they work with other community members to make changes within the city. So it's very, very important. Second thing, I don't know what the problem is here, but this is a Brown Act law violation every time you cut somebody off. So go back and read. Your little rules are out the window because the First Amendment dictates, and the Supreme Court has ruled, one can say anything they wish, especially in a public forum. So I don't know what the problem is here with you guys, but Daniel Lurie, if you're listening, you are to dismantle this commission immediately. Immediately. This is a joke, an absolute joke.
Chair Flores-Fang, we have no more callers in the queue.
Thank you. I understand that this is for, again, informational purposes, so no action is required. In response to the public comment, I wonder if we can get some guidance on whether we should return to the consent calendar.
Yes, that is correct. Sorry, I have a microphone, but yes, there's no provision for abstaining.
Okay, great. We can do that now. I think before item number 7, if that's okay. I think it can be brief. Calling, let's see, going to now recall the consent calendar. Clerk, can you please call the roll?
On the motion to adopt the consent calendar, Chair Flores-Fang.
Aye.
Commissioner Salahi.
Aye.
Commissioner Francois.
Aye.
Commissioner Ye.
Aye.
Chair Flores-Fang. With 4 votes in the affirmative, the motion is approved unanimously.
Thank you. Okay. I now call agenda item number 7, the quarterly enforcement report, including a staff presentation. I call the Director of Enforcement, B.C. Matthews. Can you please introduce the item? Thank you.
Thank you, Chair Flores-Fang. Good morning, Commissioners, and once again, welcome, Commissioner Ye. For the record, my name is B.C. Matthews, Director of Enforcement. So agenda item 7 is really the report that I bring to you once a quarter to keep you up to date regarding the status of our casework, the progress that we've made, and just to give you a sense how far we've come and where we're headed. Also to provide you with any status updates regarding projects that we might be working on. In this fiscal year, we have 2 major projects that we're working on to revise the enforcement regulations and also our streamlined administrative resolution program. So in that vein, I have Senior Investigator Eric Willett here to provide you with an update regarding the SARP revision work that we're doing, and also Senior Investigator Bertha Chung to provide you with an informational presentation regarding our probable cause and hearing on the merits process. The informational presentation that Senior Investigator Chung will provide is really important, considering the Commission's history. We've only had 1 full hearing on the merits in well over a decade, and that hearing happened over a year ago. Also, we've gained a new Commission member, and we've also gained new staff on board. So it's really important to reorient and just, remind and inform about this process. Also, we have a lot of cases moving through our investigative process. As you know, just last week, Director Ford issued a probable cause determination in a matter of William Walker. So this informational session is really timely, as it will be relevant for you because we'll in the near future, we'll be bringing matters before you that will require your engagement and action. So I'm happy to answer any questions that you may have regarding my report, but if you do not have any questions, I can hand it over to Senior Investigator Willett first, and then Senior Investigator Chung.
I don't know if you're the correct person to ask, but I just had a quick question about the interested persons meetings that happened this month, and whether there were any general trends in feedback that we should know about.
Oh, it was, yes, it did happen, and it was really positive. We got some really helpful feedback. It's good to see that folks are interested in the work that we do, and we got some really helpful pointers as well. So we'll be bringing updates to you on that in the near future, for sure.
Anything specific, or will that come in the coming weeks, like your report to us?
It will come in a report.
Great.
Yes,
Great.
for sure. Okay. Senior Investigator Willett.
Thank you, Director Matthews. Thank you, Chair Flores-Fang, Commissioners. Welcome, Commissioner Ye. My name is Eric Willett. I'm a senior investigator with the Commission. As one of my collateral duties, I administer the Streamlined Administrative Resolution Program, which is known colloquially as SARP. The Commission adopted SARP in February of 2021, and staff are currently in the process of conducting a review of that program with an eye toward refinement and possible expansion of the number of provisions of law included within the program. SARP is a enforcement program that identifies a process by which enforcement matters for certain provisions of law can be resolved through a streamlined procedure. It currently includes 41 provisions of law, and many of those are for the filing programs that the Commission administers. So think omitted filings or omitted required information. And there are also other provisions that include violations that generally require very little additional investigation or other evidence to show that a violation has occurred. And to resolve these matters, SARP identifies a eligibility criteria for each individual provision of law, as well as a standardized fine formula for resolution of matters with financial penalties. This current effort aims to address issue areas that we've identified through 4 years of implementation of the program. And we've already begun this collaborative process. We've held meetings with members of other jurisdictions. We've also reviewed some of their streamlined policy documents and current revisions that they've implemented as well. And we plan to conduct 2 interested persons meetings in the month of April, followed by commissioner engagement with a review of the proposed amendments or enhancements. And we provide that to commissioners for your review in June, with a hopeful July meeting for a presentation for adoption at that point. And as Director Matthews mentioned, this is informational, and I'm open to any questions that commissioners may have at this time.
I look forward to reading the amendments. I think that's very interesting. The only comment I'd make is that I commend the team for actually taking a look and revising where needed and kind of tweaking when things aren't working or are outdated. So I was happy to see that in the agenda today.
Thank you, Chair Flores-Fang. Great. Thank you, commissioners.
In the meantime, I did have a question for Ms. Matthews. In the report, I think that there's a number. I don't know if it's a typo. This is on page 2. It's right above the first pie chart. It's reporting the total number of represented penalties. It says $167.11.
Oh, awesome.
But you should give yourself more credit. I think it was a little bit more.
Appreciate that. Thank you. Thank you, Chair.
Should we take a break? I want to make sure that you're...
Thank you.
Oh, you're set. Great.
So thank you for the introduction, Director Matthews. So good morning, Chair Flores-Fang, commissioners, and welcome, Commissioner Ye. So for the record, my name is Bertha Chang, and I'm the Senior Legal and Investigative Analyst. So today, I will be providing you with an overview of the Commission's probable cause and administrative hearing process. And I've dedicated some time at the end of this presentation for questions, so I would appreciate if you can hold your questions at the end of this presentation. So the goal of today is for me to go through with the Commission the prosecution phase of the enforcement process and to help you understand a few things. One, how cases proceed through an administrative hearing. Two, the role and obligations of parties involved throughout the process, and your role and duty as the ultimate decision maker. So as you will see from today's presentation, each stage of the administrative hearing process entails multiple layers and steps that are governed by specified timelines and deadlines that must be carefully followed in order to ensure due process for all concerned. So on this slide, it provides you with a very quick overview of our enforcement process, from the complaint phase through case resolution, either by settlement agreement or through the administrative hearing process. The focus of today's presentation will be on the administrative hearing process, which involves 1, the probable cause proceedings, 2, pre-hearing matters, 3, hearing on the merits, and the Commission's findings. And I will particularly focus on the last 3 phases, where the Commission becomes involved. So firstly, on this slide, this provides you with a quick overview and a flowchart of how PC proceedings are conducted. So I will go through each of these steps in further details in the following slides. So first off, on the PC proceedings are initiated by the Director of Enforcement when there is a reason to believe that probable cause exists to find that a violation has occurred. A probable cause report is then delivered to the Executive Director and each respondent. As to the next step, the respondent may file a written response within 21 calendar days of the PC report. And next step, any rebuttal is due within 14 calendar days of the response. So next down the line in the process is the PC conference, which is an informal proceeding that is conducted confidentially and is generally closed to the public. Any of the parties involved, including the Executive Director and the Director of Enforcement, may request a PC conference within 21 calendar days of the delivery of the PC report. The conference is conducted by the Executive Director and provides each party with an opportunity to present evidence and make arguments regarding the existence of probable cause in the underlying matter. So at the conclusion of the PC conference, the Executive Director must make a determination in writing within 60 calendar days of the conference regarding whether probable cause exists to believe that a violation has occurred. So the final step on the slide is the ratification of the PC determination. So this is the point where the Commission becomes involved in the PC process. So the Executive Director notifies the Commission once a probable cause determination has been reached. And once the Commission has been notified of this determination, any member of the Commission may request to review this determination before it is ratified. Such requests must be made within 5 calendar days of receiving the notification of the PC determination. If no member of a Commission requests a review, then that means the Commission has ratified the PC probable cause determination, and the Executive Director will proceed to publish the final determination by delivering it to the parties and posting it to the Commission's website. However, if any member of the Commission wishes to request review of the determination, then this determination is not final until at least 3 members of the Commission vote to ratify at the next regularly scheduled meeting. So any such review is required to be conducted by the full Commission in closed session. So then the next step that I'm going to talk about as part of the administrative process is the pre-hearing matters. So pre-hearing matters include a few things. So it includes procedural matters such as filings, witnesses, exhibits, formats, and any other such matters that would facilitate the orderly conduct of the hearing of the merits. They also include matters such as disqualification of any commissioners and requests for dismissals by a respondent. Who decides? So before a matter can proceed to a full hearing on the merits, the Commission must decide on who will preside over the pre-hearing matters. The enforcement regulations provide 3 options for the Commission, including, as shown on the screen, assign an individual member of the Commission as an assigned commissioner to hear and decide on pre-hearing matters, or they may appoint any licensed attorney to preside over pre-hearing matters, or the full commission may preside over pre-hearing matters. So on this slide, you will see that there is a process in place for resolving pre-hearing matters, which I'll go through each of them. So firstly, on the first step, once the commission decides who to preside over the pre-hearing matters, parties may request resolution of any such matters by submitting motions for consideration. There are a few steps down the process. So as you can see on the slide, the enforcement regulation sets forth the process for requesting consideration of pre-hearing matters, including the timeline and the method for the submission of such requests and any responses and replies. So the enforcement regulation also provides for a 15-10-7 calendar day deadline for submissions. However, as outlined in the enforcement guidebook, this timeline was determined to be impracticable for a number of reasons. For example, it does not provide sufficient time for full review and resolution of any pre-hearing matters, nor does it provide sufficient time for the review by the rest of the commission of any rulings made by the assigned commissioners, if such review is requested by any party. And there's also probably not enough time for the submission of hearing briefs prior to the hearing on the merits. So as such, in the last concluded hearing before this commission in the matter of Paul Allen Taylor, the commission instead adopted a 30-15-10 calendar day submission deadline timeframe, as shown on the slide, which provides for a better defined timeline that ensures a fairer and more efficient process for all parties. So finally, on this slide, as for the process for submission of motions, submissions may also be done via mail per the enforcement regulations, but this commission voted in the Taylor matter to allow submissions via email. So next, once the pre-hearing matters have been concluded, if an assigned commissioner presided over such matters, then the assigned commissioner would provide any determination on the pre-hearing matters to the commission, and all parties either via written determination, as adopted in the Taylor case, or verbally at the next regularly scheduled meeting. And should any objections arise regarding the assigned commissioner's determination, the commission may review such objections by adopting the same rectification review process for the PC probable cause determinations, which I covered in the earlier session of this presentation, or set forth a different review process that allows the commission to hear and rule on the issues raised by the requesting party, or review any disputed pre-hearing matters when the full commission takes up the case at the hearing on the merits. So that concludes the pre-hearing matters phase. So once all the pre-hearing matters are concluded, the hearing on the merits itself will commence. So a hearing on the merits is a formal proceeding to resolve whether or not a respondent has violated the laws administered by the commission. So the hearing on the merits is open to the public and held within a regularly scheduled meeting or in special sessions. So the executive director will schedule the hearing on the merits and is required to deliver written notice of the date, time, location of the hearing to each party at least 30 calendar days prior to the commencement of the hearing. And to proceed with the hearing on the merits, the executive director is required to submit a hearing brief 30 calendar days prior to the hearing on the merits. Respondents, however, are not required to, but they may also submit a hearing brief 15 calendar days prior to the hearing, and any replies would be due 7 calendar days prior to the hearing. So as to who decides, so the commission may choose to delegate authority to preside over a hearing to a hearing officer. The Commission may make this delegation at the time it appoints an assigned commissioner for pre-hearing matters or at any other point before the hearing commences. If it does not delegate the authority, then the entire Commission will preside over the hearing as a whole body. So as to the presentation of the case, this is somewhat similar to a trial. So for example, you will see that on the administration of oaths and the affirmations, the Commission may administer oaths or affirmations to begin the proceedings, after which each party will be given a specified amount of time to present their arguments. So parties may also introduce exhibits as evidence, and they may also conduct witness examinations. So on oral arguments, so each party is allowed up to 15 minutes to present their arguments, with 3 minutes for rebuttal. And the 15-minute time limit applies to opening and closing arguments and not the process of presenting evidence through witnesses and exhibits. The Commission may also extend the party's argument time if need be. For the exhibits, so parties may use exhibits to introduce evidence during the hearing, including emails, objects, recordings, photographs, and unless stipulated by the parties, the Commission or the hearing officer must determine whether each exhibit is admissible. So regarding witnesses, witnesses shall be examined first via direct examination by the party that called the witness, and the witness shall then be examined by the opposing party via cross-examination. The party that called the witness then will be given the opportunity to conduct a redirect examination of the witness. Any examinations after the examination by all parties, then the Commission shall have the opportunity to ask questions to the witness. And at the conclusion of the hearing, the Commission must make its findings, which I'll cover in the last session of this presentation. So as mentioned, the final stage of the hearing on the merits process is the Commission's findings. So the Commission must make its findings no later than 45 calendar days after the conclusion of a hearing. And the Commission may make a finding of violation or a finding of no violation. So I'll first talk about the finding of violation. So a finding of violation is when the Commission finds that a violation of law has occurred, and that the respondent caused the violation of the law to occur. So the standard of proof that must be met in order for the Commission to make a finding of violation is the preponderance of the evidence standard. And as most of you know, this is the standard that pertains to a civil trial, which is much different and much lower than the beyond a reasonable doubt standard in a criminal trial. And here the Commission only needs to find that it is more likely than not, or there is greater than 50% chance that the respondent committed a violation of law. If this standard is met, then the Commission may make a finding of violation by a vote of at least 3 commissioners. The finding of violation must be supported by findings of facts and conclusions of law and must be based exclusively on the record of the proceedings before the Commission. So before reaching a finding of violation, each commissioner who participates in the decision must certify that they personally heard all of the testimonies, either in person or by listening to a recording of the proceedings, and that they reviewed the evidence and the entire record of the proceedings. And if by vote of at least 3 commissioners, the Commission makes a finding of violation of law, and the Commission may issue orders or penalties requiring the respondents to do a few things. For example, cease and desist the violation, file any reports, statements, or other documents required by law, pay a penalty to the general fund of the city, order forfeiture of the campaign contributions that do not comply with the law, or any other reliefs that the Commission deems appropriate. And finally, on the other hand, for finding of no violation, the Commission may determine that there is insufficient evidence to establish that the respondent committed a violation of law, or that there is sufficient evidence to establish that the respondent did not commit a violation of law. If so, the Commission will publicly announce this finding, and no further action will be taken by the Commission to review or investigate the allegations contained in the complaint. So this is the end of the presentation, and I hope I've given you a comprehensive overview of the probable cause and administrative hearing process. As you can see from this presentation, the administrative hearing process entails multiple layers and steps that can take some time. But I'm sure you can all appreciate that this process is a very vital tool at the Commission's disposal that empowers it to leverage and force penalties against respondents who have violated the city ethics law and who do not admit to such violations or otherwise would not settle a case with us. So I hope you find this presentation helpful, and I'm very happy to take any questions at this time. Thank you.
Thank you very much. I have no questions, but do my fellow commissioners have any questions?
Thank you. A few questions, and maybe they stem from my ignorance of the process. Maybe I missed this, but are pre-hearing matters public, or are those held in closed session?
The pre-hearing matters is in closed session. So, therefore, as you can see, Commissioner Ye, that there are a few. Oh, yeah, thank you. Yeah.
It's a good question. So, like I mentioned earlier during my introduction, we've only had one hearing, and at the time there was an assigned commissioner. So parties worked with the assigned commissioner to resolve the pre-hearing matter, so it was not during open session. It could be if there was no assigned commissioner and the entire commission decided to preside over the pre-hearing matters. And at that point, it would be required, to avoid any Brown Act violations.
And then, are there discovery mechanisms for the parties? So how would they, for example, get the necessary documents or compel witnesses to appear at any stage of the proceedings?
There are discovery mechanisms. Parties can, use requests for information, subpoena, every mechanism that's used in any hearing, pretty much. So we're able to do that, and we are able to do that throughout the investigative process, and also once we hit the administrative hearing process. Yeah.
I did have one question that occurred to me. When we had the proceeding with Paul Taylor, I remember there being some discussion about how we actually mechanically go through the process of preparing the findings at the end, given that it requires some wordsmithing, but we can't collaborate outside of the hearing on editing for Brown Act reasons. So I'm curious whether before we proceed potentially with a second one, there will be any recommendations from staff on how to refine that process.
We are happy to make those recommendations. We plan to include those in our notice to initiate the pre-hearing matters, so that will be forthcoming. Of course, respondent will have to also have the opportunity to respond to our recommendation, but we certainly share the same sentiment and want to make sure that this time around things move a little smoother.
Thank you. Thank you.
Thank you, Commissioners. Any public comment in the room? If not, Clerk, can you please check the queue?
Chair Flores-Fang, there are 0 callers in the queue.
Thank you, Clerk. Public comment on item 7 is now closed. I now call agenda item 8, discussion. Sorry, were you going to say something, Clerk?
Oh, so.
No? Okay. Discussion and possible action on items for future meetings. I had one thing I wanted to circle back on from the last meeting, but I don't know if my fellow commissioners have anything they'd like to present. This has to do with an item that Commissioner Salahi raised at the last meeting. I know that he raised that Supervisor Chen asked if we had any guidance, and I know that Director Ford graciously offered to engage. Not sure if that's happened, and not putting anyone on the spot, but just wanted to keep that moving. I also wanted to add that we had discussed maybe providing more public clarifications or additional information for the public, given that question on behested payments. So I think it's two separate follow-ups, like whether we followed up with Supervisor Chen and then whether we want to do something more publicly.
Sure. For the record, Pat Ford, Executive Director, we did follow up with Supervisor Chan's office and offered to meet with them. We have not heard back from them. So we can follow up on our follow-up and see if they still want to engage on that. But short of that, I'm not sure exactly what they're looking for. So rather than sending something off into the ether without really knowing what the supervisor is asking for, I don't think it's a good thing to move forward on. I really want to understand what is the need that they are feeling, engage with them in a dialogue, look at what exceptions they have been granting. I mean, we follow them, but really understand what issues they're having, what process they're looking for, how we can support it.
Great. Yeah, and then I think we can provide, I mean, I don't want to expose whatever questions they had, but to, like, I think guided from, from that conversation, we can maybe present something at the next meeting or like whenever you speak to them, just to clarify a few things. If that
Sounds
works.
good.
Great. And I think that can be whenever, but given that it came up, I think it's important. Okay. Do we have any public comment on this? Anyone in the queue, clerk?
Chair Flores-Fang, there are 0 callers in the queue.
Okay, public comment on agenda item 8 is now closed. I now call agenda item 9, additional opportunity for general public comment. Anyone in the room who wishes to give public comment? Clerk, anyone in the queue?
Chair Flores-Fang, there are 0 callers in the queue.
Okay. Thank you. Item 9 is now closed. I realize I've not been doing this, but here we are.
We have to redo it all.
Yeah, I think we should start. We're happy to go through. This is a lot of fun, but I think we can proceed to agenda item 10, which is adjournment. Thank you. This concludes the March 14th, 2025 meeting of the San Francisco Ethics Commission.